Welcome back. Let's move on to the next topic, former adjudication. Perhaps you've heard about the concept of double jeopardy, which is a constitutional prohibition against the government twice bringing criminal charges against you for the same underlying crime. Well, there is a somewhat similar concept in all litigation, which says that once you have a bite of the apple, the system needs to attach finality onto whatever resolution was arrived at in the first case. So we have these doctrines of former adjudication, claim preclusion and issue preclusion. To complicate things even more, the terminology here is not straightforward. I will be talking about claim preclusion and issue preclusion, but as we'll see, in the cases that discuss these concepts, other terms are used as well. Most commonly, claim preclusion is referred to by the Latin phrase res judicata. Issue preclusion is referred to by the old-fashioned phrase collateral estoppel. And then there are also other terms, such as merger and bar, that can be seen in the case law in this area. So that's one reason why this particular doctrine can be a little bit confusing. A second reason why first-year students often find this a bit challenging is that the doctrines of former adjudication are not reduced to rules or governed by statutes. Rather, the doctrines of former adjudication are largely common law doctrines, doctrines that have been created and elaborated by courts over time. So you'll note in my outline of Chapter 1, under the topic of former adjudication, there are no rules of civil procedure to be interpreted, nor are there any federal statutes that define the relevant standards. Rather, we're going to be looking at a body of decisions handed down by courts. Do not be surprised if you found this section to be difficult. This is a conceptually demanding topic. Courts use different terms, and as I just said, there are no rules and there are no statutes. And so, all of that can be a little bit disorienting. So, with that as background, let's now talk about Isom versus Thomas. What court are we in and why?
This is an appellate court review of what happened in the lower court in a state court trial.
Great. What are the facts?
The plaintiff is suing because he was injured in a car accident.
Why did the plaintiff bring this claim?
The plaintiff is appealing a motion for summary judgment entered in the lower court.
Good. Online student, do you have anything to add? So this is a case where a guy named George Isom is appealing from a summary judgment in a state court in the state of Kentucky, dismissing this claim against the defendant Anthony Thomas for personal injury damages arising out of an automobile accident. Now you might be kind of confused here. What's going on? Online student?
I think there might be two different lawsuits about the same accident.
Yes, that's right. Mr. Isom formerly filed a lawsuit against Mr. Thomas arising out of this same action. Isom filed a lawsuit claiming that Thomas injured him in an automobile accident in Kentucky. We're told that soon after the accident, in August of 2003, Isom sued Thomas and Thomas's insurer. Note, by the way, that in some states where there is an insurer standing behind a defendant, the plaintiff actually can sue that insurer directly. In other states, however, plaintiffs simply sue the other party, and the insurer sort of stands in the background. Some states don't like to allow lawsuits against insurers. Why?
Because they're worried that if juries know that there's an insurance company involved, then it becomes a little bit easier for the jury to say, let's just let the insurance company pay. They have deep pockets. Let's let them provide coverage here.
Exactly. So what is the rule in Kentucky?
Kentucky does allow for suits against insurers.
Good. What is the issue in the first case?
The first issue in the case is whether the defendant is liable for damages to plaintiff's car.
Great. All right. Isom sues Thomas in this first case. But here's what's important to understand. In that first case, Isom sought damages only with regard to the damage to his property, his car. He did not seek damages for his personal injuries. So, in a lawsuit by Isom against Thomas, case number 1, Isom sues Thomas and the insurance company. Now, what did the court decide? Online student, what do you think? The jury returns a verdict for the plaintiff and awards damages of $5,000 for property harm. That ends the case. Then what happens?
Well, what happens is that Isom filed this lawsuit and now wants to get personal injury damages.
Great. Isom files a second lawsuit against Thomas saying, okay, that same accident also caused me personal harm. It caused me personal injury. What is the plaintiff's procedural claim in Case 2? Online student? He's saying that since Case 1 already determined that defendant caused the injuries, there isn't any reason to relitigate this question. While the case doesn't specify the actual procedural claim, we can infer that Isom argued that since we already know that Mr. Thomas breached a duty to him that caused him damages in Case number 1, all we need to do in Case number 2 is to have a trial on the amount of damages caused to his person. What is the legal doctrine argued by the plaintiff? Online student?
The plaintiff is claiming issue preclusion. He wants to preclude the issue of personal injury from being relitigated because he says that has already been decided in the first case.
Good. In making that argument, Isom is attempting to use the doctrine of issue preclusion or collateral estoppel. He is arguing, in other words, that the issue of Thomas's negligence has already been decided in Case number 1, and that Thomas should not get another bite of the apple to disprove what was already proven. Case number 2 should simply be about how much money Isom should be awarded for his personal injuries. But Thomas has an argument in Case number 2 as well. What is defendant Thomas's argument?
The defendant says that the plaintiff's claim is too late.
Online student, do you have anything to add? So Thomas says, no. Under Kentucky law, you don't get to do this. You don't get to split your claim in half like this. Case number 1 was about all of the damages caused in our accident. In case number 1, Isom, you chose only to seek property damages. That was your choice, but after that case was resolved, you lost your opportunity to seek personal injury damages. What legal doctrine is the defendant asserting? Online student?
Thomas is arguing claim preclusion. He says that Isom lost his chance to get personal injury damages because he should have made that claim in the first case.
Exactly. Thomas is invoking the doctrine of claim preclusion or res judicata because, under that doctrine, one loses the right to claim for damages arising out of the same transaction that was the subject matter of the first case. The doctrine of res judicata or claim preclusion, in other words, bars you in the second suit from seeking damages that you could have sought in case number 1, but neglected to do so. What did the court decide?
The court agreed with the defendant.
The trial judge in this particular case agrees with the defendant and dismisses case number 2, telling Mr. Isom, sorry, you had your chance. The doctrine of claim preclusion, of res judicata, bars this second suit. Does the appeals court agree with the trial court?
The Kentucky Appeals Court agrees with the defendant.
Right. On what basis?
Because Kentucky prefers claim preclusion?
Not exactly. Anyone else? What does the court say about quote-unquote claims?
Oh, it says that the word claim is broad enough to encompass all damages arising from the transaction or occurrence which caused the harm.
Good. The court says, under Kentucky law, the definition of the word claim is broad enough to encompass all damages arising from the transaction or occurrence which caused the harm. And so, it upholds the trial court's decision. At the end of the day, Mr. Isom is out of luck in this case. So a couple of things to take note here. First, you may be wondering, why the heck did Mr. Isom's lawyer do that? Online student, what do you think? Now, I'm not going to be telling you you're wrong to be asking what the heck was going on, because it does seem as though the law in Kentucky was well established at the time this case took place. The opinion in this case makes mention of a case called Kirchner v. Rerecord from Kentucky in 1985. That's a Kentucky Supreme Court case, the highest court in Kentucky, and therefore the rule in that case would of course be binding on all state courts in Kentucky. What was the issue in that case, and what did the court decide?
The Supreme Court said that you can't sue a second time on the same issue if the case was already decided once.
Online student, do you have anything to add? The Kentucky Supreme Court ruled that the law will not permit a party who has sued for part of an entire demand to sue for the residue in another action. In that case, the court reaffirmed its adoption of the Restatement Second of Judgments, Section 24. What does the court mean by that?
Well, the restatement says that you can't sue a second time for the same thing.
Why?
Because it's fair to everyone. Because there's finality then. So claims are precluded if they've already been decided.
Great. Section 24 states that when a valid and final judgment rendered in an action extinguishes the plaintiff's claim, the claim extinguished includes all rights of the plaintiff to remedies against the defendant with respect to all or any part of the transaction or series of connected transactions out of which the action arose. This is the broader definition of claim preclusion that has been applied in many jurisdictions, but not all. We will see this later in the course. So, Mr. Isom's lawyer made a big mistake. Mr. Isom's lawyer apparently did not know at the time of the first trial that Kentucky had adopted the broader definition of claim. The plaintiff's lawyer apparently didn't do his research or her research and didn't know that there was this broader definition of claim preclusion that had been adopted by the Kentucky Supreme Court. It was a mistake. Beyond that, you might be wondering if there was any other reason why Isom did what he did. Why would he split his claims in this way? Think about that question from a strategic perspective. What might be the strategy here? Jane?
I'm not really sure.
What would be the advantage to having the defendant's liability already determined? How could that help the plaintiff in a second trial?
Maybe because you might get more personal injury damages in a second trial?
Not quite. Online student, anything to add? What about the Kentucky law that says plaintiffs can also sue the defendant's insurance company? How might that factor in?
Well, if juries want insurance companies to pay, then they find the defendant liable for property damage, and then they go to a second trial and just ask the jury for personal injury damages. It might make it easier to get a verdict for the plaintiff.
Good. To sum up, we already have made mention of the fact that in Kentucky, you could sue not only the defendant, but you could also sue the defendant's insurance company. Mr. Isom's lawyer knew that in case number one, there would be an insurance company defendant. Doesn't it potentially at least make sense strategically to make case number one simply about the damage to your vehicle, knowing that the jury's going to look at it and say, we have an insurance company defendant here. We're talking about $5,000. Let's make the insurance company pay. The idea is that seeing an insurance company in a case like this is going to have an effect on the jury, or at least might have an effect on the jury, and might make it easier for the jury to find liability. Strategically, then, you get your verdict in case number one, if you were allowed to split claims like this, and then you take that into case number two. Let's imagine that the evidence here in this case was pretty close. Maybe there's a lot of evidence that Isom was also comparatively negligent. But now, in case number two, if you're allowed to split your claim like this, the doctrine of issue preclusion or collateral estoppel takes the question of liability, i.e. whether there's been a breach of duty, completely off the table. The plaintiff says, we don't even have to have a trial anymore about whether there was negligence. Case number one established that. Let's have a trial now about personal injury damages. That's a very different claim. I'm claiming damages here to my person rather than simply damages to my property. Claim splitting of this sort was actually permitted in a number of jurisdictions, although the trend has been away from that. But note that there is a strategy behind what appears to be Mr. Isom's lawyer's mistake. You go get your verdict in case number one, you have an insurance company defendant in case number one, and then you take that liability finding and you bring it into case number two and you use it offensively. And in a case where the stakes are higher, and perhaps in a case where the evidence is close, you take the liability question off the table. Case number two simply becomes about damages. And so, plaintiffs' lawyers used to do this in jurisdictions which allowed claim splitting, because there are incentives for doing so. Mr. Isom's lawyer's mistake was that he or she did not realize that Kentucky had already adopted a broader definition of the concept of claim. And therefore, the lawyer made a legal error that caused Isom to lose his opportunity to seek personal injury damages. So what does Isom do now?
I think it means that Isom is going to sue his first lawyer.
Most likely, if at the end of the day Mr. Isom is looking to recover for personal injury damages, and surely he will be, the defendant is not going to be Mr. Thomas. the defendant is going to be Mr. Isom's former lawyer. And the claim is going to be one for legal malpractice that caused him harm in that it negated his ability to be able to recover for damages in the earlier lawsuit against defendant Thomas. Okay, we'll continue our discussion of this in the next lecture.